Roll call, please. Here.
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 Are there any conflict of interest statements?
No.
No, sir.
Approval of the minutes of the meeting of May 23rd, 2024.
Motion to approve those minutes.
And I second.
All in favor, say aye.
Aye.
Bid openings, I don't see any. Number 6, matters from other department heads or their representatives. Nothing? Okay, we're going to move on to correspondence. Letter A, correspondence received from Jeffrey Smith, Fire Chief, requesting the approval of the resignation of EMT 1 David Baltima effective the close of business on April 21st, 2024. Retirement of Fire Chief Jeffrey C. Smith, who has served the citizens of Hammond for more than 32 years, effective June 1st, 2024. And the promotion of AC Drill Master David Weiss to be promoted to the rank of Deputy Chief, and the promotion of Deputy Chief Bernard Grizzolia to be promoted to the rank of Fire Chief, for both effective June 1st, 2024. First of all, I'd like to thank Jeff for his service for 32 years. If we give him a round of applause, please. And although I've never called him Bernard, congratulations, Bernie. Okay.
Motion to approve Chief Smith's request.
And I second that.
All in favor, say aye.
Aye.
Letter B, correspondence received from Chris Campbell, Director of IT Department, requesting the approval of the participation agreement with AT&T Enterprises LLC for SIM card. I'm guessing we're okay with that, right? Kevin, are we good with that? Yes, sir. Okay.
Motion to approve.
I second.
All in favor, say aye.
Aye.
Letter C, correspondence received from the Controller's Office requesting the approval of the renewal of amusement device license for UFO Bar and Grill.
Motion to approve.
I second.
All in favor, say aye.
Aye.
Letter D, correspondence received from resident Sharonda Burnett requesting to block off 6720 Marshall Avenue on Friday, June 7th, 2024, from 1:30 p.m. to 8:30 p.m. for a graduation party. It has some signatures on here also.
Motion to approve.
I second.
All in favor, say aye.
Aye.
Letter E, correspondence received from Dean Button requesting advertising dates of June 6th, 2024 and June 13th, 2024, with a bid opening of June 27th, 2024 for the 165th Street and State Line Road intersection improvements project submitted for approval.
Good morning to the board.
Good morning, Dean.
Thank you. So as we're all aware, this is an intersection that's sort of a difficult one, particularly if you're eastbound from Calumet City coming into Indiana, into Hammond. There's that turn. And so what we're trying to do is make improvements, guardrail, rumble strips, to keep folks from leaving the roadway onto the private property. And so we'd ask for your permission to go out to advertisement for this project.
Okay.
Motion to approve.
I second.
All in favor, say aye.
Aye.
Thank you.
Thank you. Letter F, correspondence received from Tamara Bunch, 1106 Drackert Street, to block the corner of Drackert Street and Howard Avenue on June 8th, 2024, from 3 p.m. to 8 p.m. for a birthday party with signature attached. 1106, I wonder if they're going to block, just that corner.
Just a corner?
Not a
Yeah.
road. I think we're, yeah.
Motion to approve.
I second.
All in favor, say aye.
Aye.
Number 8, matters from board members.
No, sir.
Have anything?
Nope.
President, no.
Okay. Number 9, new business. Letter A, demolition hearings.
Good morning to the board.
Good morning.
We do have several these are all new demolition hearings for today. I would want to just place on the record that under the Unsafe Building Act, these buildings or structures were determined to be unsafe as defined in the act. Also that service has been effectuated in the following manner under the Unsafe Building Act, specifically by certified and regular mail to the owner or those with a substantial property interest, through publication in the Times, as well as by posting on the properties. So I believe that the board will be able to find that sufficient service was given to the people and notice was given to the persons that either own or have a substantial property interest of these properties. I do, for the board, have, of course, all the materials that substantiates the inspections department's findings that these are unsafe structures. We do have some updated photos as well. I have a binder of the photos of the condition of the properties, and I will, at the correct time, give some updated photos as well on some of the properties. So if I could give you the binder?
Yes.
And then we can proceed.
Okay, and it looks like we're going to start with letter A, 7817 Bertram, the garage.
Right, so this is an interesting place to start. The address was determined through this process to be Delmar, so we need to dismiss the 7817 Bertram garage matter, and we will reset it when the folks at 7817 Delmar get notice about their garage. So we'll get that reset probably for a June or July date.
Okay, so we don't need to make a motion for that, just move on?
I'm happy for you to make
Announce-
a motion to remove 7817 Bertram. That way those folks, I can get them a notice that they don't have anything to worry about with their garage, which I'm sure is in great shape.
Okay, yeah.
Motion to remove 7817 Bertram and reset this for 7817 Delmar at a later date.
And I second.
All in favor, say aye. Aye. Okay, then moving on to letter B, 5742 through 52 Calumet, garage and rear structure.
Right, so this is a structure that's kind of remaining at this used car lot right over here on, I think it's Becker. However, Mr. Craig, who is the attorney for the beneficiary of the trust, Mr. Borsuk, hi.
That's me, Chester Borsuk.
All right, here he is in the flesh. So, Mr. Craig is the attorney for Mr. Borsuk, and he's asked for a continuance of today's hearing, which I don't object to. He had another matter he wanted to attend to. Mr. Borsuk, is that your understanding that Mr. Craig's representing you in this?
Yeah, I could see if I can handle it here.
It's totally up to you. I just want,
Yeah, I
because
can
I
handle it.
can't, my conversations with Mr. Craig, who's asked for a continuance. If Mr. Borsuk wants to move forward without Mr. Craig's advice, I think you need to make sure he understands that.
We can move forward.
Okay, you understand that you have the right to, we can reset it and have your attorney here with you,
Yeah.
correct?
Sure.
Okay, and you're still choosing not to do that?
Yeah, that's fine.
Okay,
All right, so then the city would present the photos in tab 2. Mr. Borsuk, I believe, is either the trustee or the beneficiary of the trust that owns the property. It is I think at one point it was a used car lot or a car lot on the west side of Calumet, just up the block here. You can almost see it, actually. I believe it's on Becker and Calumet. And there's a structure in the back that's kind of become a haven for graffiti and other matters, and that's the structure that we'd like removed.
okay. Sir, what do you have to say about that?
Well, we're going to repair it up and clean it up.
How long have you been aware of this issue?
You know what, we send people out to do our maintenance, and first sign I have is this, that I got a notice to come out there and get it straightened out. We're going to do that.
So the first time that you knew you had a problem with graffiti is today?
Yes.
Okay. Do we know if that's accurate? Has anybody spoken with him before?
I don't know if Mr. Schultz is here. Yes.
I have not spoken with him before. We did have our graffiti removal team come out and clean up some of the graffiti, so it is clean now, but it is a reoccurring problem.
Okay, and Robert, are you asking for the structure to be removed, or are you just asking for it to be kind of rehabilitated and fixed up?
Well, I had been requested by Mr. Farrell that we have that building removed to get rid of this problem.
Okay, so the city's position is they want it demoed. If Mr. Borsuk believes that he is going to utilize that building or has a use for that building, I'd like to hear it.
I think it's a usable building for storage or so, if somebody decides to take that operation over. We have it for lease at this time.
Well, I understand it might be usable in your mind, but do you intend to use it? Because if you use it, then I have a better idea that you would maintain it.
Well, I'm going
It's
to
a-
have to maintain it because I'm here.
So I guess the question would be to the city would be, is there anything he can do to stay off the demolition list?
Sure, I mean, in these situations, what we usually try to do is to enter the order of demolition and allow Mr. Borsuk, and to stay it, to allow Mr. Borsuk to meet with the city to get a plan together to rehab it. And it sounds like that's what he wants to do.
Yeah, that's fine, because it
Yeah.
doesn't really need much, but I mean, it's got graffiti on it and so on, and I was not aware of that.
Okay, so as long as we can get his contact over to Mr. Kearney and to Mr. Schultz after this hearing, that'd be great. And city would request an order of demolition, but of course it would be stayed pending having to bid it out if he doesn't get a hold of them and get the rehab moving, so.
Do you understand that, sir?
I'll get a hold of them.
Okay. We'll go ahead. Yeah.
Motion to enter the demo order.
I second.
All in favor, say aye.
Aye.
Okay, sir, stay in touch with them, and hopefully you guys can work something out.
Thank you very
You're welcome. Have a good day. Sure. Okay, moving on to letter C, 6411 Harrison.
6411 Harrison is tab 3 in your book. It's a single-family home listed as owned by Maria, Jesus, David, Daniel, and Jimmy Garcia, who, the only address we have for them is 6646 Jackson Street. The property's been boarded, listed as uninhabitable as of April 3rd of 2024. It appears to be in significant disrepair, including open holes in the front, exterior walls, gutters failing, abandoned vehicles on the property, and peeling paint. The city's position is that we'd like the demolition order affirmed so they can move forward with demolition.
Could we have your name, please?
Yes, it's Jimmy Elias.
Okay, could you tell us what's going on with the address?
Yes, the house is under my brother's name, Jesse Garcia. He's actually in Arizona. He's in the process of getting the house sold. So he's actually on his way to Indiana to get this property sold, just to avoid all this.
The process hasn't been started yet. He's going to start it when he gets here?
Yes.
Okay.
So I just want to advise Mr. Elias, did you get notice, by the way, at the address we sent it to?
I got a notice about 2 weeks ago. This is the first time I've gotten this notice.
Was it the correct address, though? Did we send it to you at the right address?
You did.
Okay. So what I would advise Mr. Elias is that he lets his brother, I think he said, did you say which
Jesse.
brother? Sorry, Jesse, is that Jesus?
Yeah.
Okay. That if he does sell it, and the board does affirm the order today, which is what we're asking, that Jesse needs to advise any subsequent owner of that. He has an obligation to advise the subsequent owner of the demolition order, and that either that person needs to either decide to buy it with that demolition order on the property or work with the city to rehab the property if there's time to do that. We're going to move forward, though.
You
We'd like to
understand?
move forward.
Do you understand that?
Yes, but I mean, as far as demolition, is that something that you're gonna like move on, or?
No, it's a process. It would take approximately,
Probably 8 to 10 weeks to get a bid, and then it would be after that where we would then have to award the bid, and then they would have to get a hold of IDEM and get a 10-day notice and get a permit and a contract signed. So we're probably talking somewhere between 8 to 16 weeks.
2 to 4 months.
2 to 4 months.
So that should give you plenty of time to try to sell the house.
Oh, okay,
You just have to notify whoever you're going to sell it to that this
This is
is on there, okay?
okay.
You understand that part?
do.
Okay, so we're going to move forward because we have to keep the process moving.
You know what? I do have a comment.
Okay.
This house is not in my name, and I got this letter as well as my brother's, so I don't know how to get my name out of this list.
You want to be out of it even though you're here representing it today?
Well, my brother's in Arizona. My mom and brother are shut-ins, and I was the only one to be able to come.
Okay.
But the house right now is under my brother's name only, Jesse
the-
Garcia.
So the house, at least according to the title work I got, is actually under Maria S. Garcia. Just so you know, if there was a deed, I think there was a deed that got rejected by the county, so you guys probably need to look into that. Because, I know what it is. Your mom's still alive, right?
Yes.
Okay, so the last deed is a transfer on death deed. So what that means is that your mom actually is still kind of like the owner until she passes away.
Okay.
And just so you know, what the deed says is transfer on death to Jesus, David, Daniel, Jimmy. So you're on the deed.
Okay. I don't know how, I mean, you're gonna go forward with the demolition in 6 weeks or more, but, you know, how do I change this? Because I wasn't aware that was the deed that was upon her death.
Well, I think the process at this point would be you either have to sell the house or you have to meet with the city and have an inspection done and show them that you have the ability to make the repairs that are needed, which are going to be significant, obviously.
Yeah.
So you have to do that in the next 8 to 12 weeks.
And if you're asking about how to get your name off the deed, you need to consult with another attorney to do that, and they'll be able to advise you, because we can't give you legal
I mean,
advice.
I just want to be clear. At this point, are you guys moving forward with the demolition?
Correct, yes. We're moving forward with the process.
There's
It won't be demoed, like he said, for 8 to 16 weeks.
There's nothing I could do at this point to stop that or to get an extension until he gets back to Indiana.
Well, you said he was on his way. I mean, what can it take, a couple days?
Yeah, I mean, I haven't spoken to him. We haven't spoken in years, but his wife just called me and said that she sent him some money so he could come. He could come.
Is that Carmine?
Yeah.
Okay, so just to make the record clear, I got a call on Tuesday, 2 days ago, from Carmine Garcia, called regarding her and her husband, which is Jesse's property, and that a hearing was coming up today. She was wondering if there was any way to get an extension to next week because they were traveling, and her husband might not be able to make it back in time. Her number is, and then she gave her phone number. They asked for continuance. If this needs to be set over for 1 week, I'm fine with it being set next week if Mr. Garcia is going to show up. If you want to let your brother Jesse know, I mean, that at least gives him the opportunity to be heard by the board.
You know what? To be honest, he's not very reliable. And then if you could give maybe 2 weeks, maybe 3. 'Cause
No, I think a week's fair. It was supposed to be heard today, so we are allowing that 1 week time. So you said he was on his way, now you're saying 2 weeks.
Oh,
I think a week's fair.
A week, okay.
Okay, we're gonna set this over for next week, but I think that's more than fair.
So there's another hearing I got to come to, or
Same,
him.
or him,
Or
yes, yeah. Next week, Thursday, 9 o'clock, same time,
Okay,
okay?
Thursday next week, 9 o'clock.
okay. Thank you.
Okay,
Okay. Motion to set the matter for status for June 6, 2024.
I second.
all in favor, say aye.
Aye.
Okay, moving on to letter D, 5125 through 27 Homan Avenue, restart of demo that expired.
Yes, so this property actually we didn't get the title work in time, so we're going to reset it for another date. You won't even have the photos in there of that.
Gotcha. Okay. Moving on to letter E then, 54 Mason, the rear.
54 Mason rear, I do have updated photos that were given to me by Mr. Castro, or maybe Schultz gave me those. 54 Mason, this is the rear part of this. I believe the owner is listed as Brenda Bergen, and there is a mortgage on it. The inspection report notes that the property is in general disrepair, the fence is collapsed. There are areas where doors are not provided where required, and exterior windows have not been fitted on the property. The photos that I've given you show that the rear of the structure have open gaping holes, and there's a peeling paint and a collapsed fence. So it appears to be the rear of the structure, right, Rob? Okay. So that's where we're at. Given the condition of the property, we'd request that the order be affirmed for the rear of the property.
Good morning, sir. Could you give us your name, please?
My name is Scott Hale, representing Truist Bank, who does have a secured mortgage interest in this property.
Okay.
And do you mind if I ask, Attorney Smith, do you happen to know if the property is vacant, or
Rob, do you know?
do you have a report on that?
My understanding from water is that the property is vacant.
It would be hard to believe somebody would stay there with that the back the way it is, as open it is.
Scott, are you with SunTrust? Is that your client?
Truist.
What is it?
Truist,
How do you spell that?
Truist.
Truist, is that a bank or mortgage company?
Correct.
Bank, Truist Bank, okay.
Okay.
And so currently, we're in the process of determining whether we're able to secure the property. The biggest hangup was determining whether the property was occupied or not. With that information, a property inspection was ordered by the bank on May 21st, 2024. We're still waiting on the results of that inspection. At this time, we're requesting a 60-day continuance of this hearing to take a look at what needs to be done with the property, see if the team can secure it, and then if we need to enter into a rehab agreement, we'll be able to do that. By the way, do you have pictures of the property that I can take a look at?
Yeah, sure.
Thank you.
Yeah, it's only about a 2-minute drive
All right.
from here, so
Yep.
you could even pop over if you want after the hearing.
So what's the city's position?
City's
on the
position
2
is we'd
months?
like to move forward. It's no disrespect to Mr. Hale, however, you know, we've seen hundreds of these come through, and, you know, banks always have the right intention, but there's a lot of kind of red tape a lot of times with banks that they need to go through their property management, they need to go through an inspection, they need to get it up through their property rehab committee and things like that. So the only thing that I think kind of keeps everybody on task is to allow the process to move forward. Of course, we'll stay in contact with Mr. Hale, and we'll make sure that we, you know, let him know what's going on in the process. I have his information, and we can, of course, keep him updated when we bid it out.
You understand that, sir? The best plan for us is to move forward with it. You have more than enough time to do whatever it is you're going to do. We're just going to continue with it so we make sure it keeps going forward, okay?
I understand, thank you.
Okay, so we'll go ahead and affirm it then.
Motion to enter the order.
I second.
All in favor, say aye.
Aye.
Okay, sounds good.
Okay, thank you. Letter F, 1152 Michigan.
All right, 1152 Michigan. We have the owner listed as, I have some actually updated photos from Mr. Castro. If I can present those to the board. Should be tab 5, I believe,
Yeah, looks like the same one.
in your list here. 1152 Michigan. The owner's listed as Raymond Siegel of Yorba Linda, California, with a mortgage by J.P. Morgan Chase Bank. Property is described, this has been a police activity situation as well. I know that Mr. Castro indicated in his report that the interior walls were removed by the owner without permits, compromising the ceiling of the roof structure. The owner broke out every window in the house, has thrown debris out the front windows onto the sidewalk, which has impacted the safety of the neighbors and other vehicles that may be going down Michigan. It's currently vacant due to the condition of the structure. As you can see, it's been boarded up. Due to the condition of the structure, it should be demolished. So that's kind of our position.
Okay. Good morning, sir. Could you give us your name,
I'm
please?
Steve Meeker from Meeker Real Estate. I represent Chase Bank.
Okay.
I'm not the owner of the property who threw the stuff out the window, but I got a full report from the neighbors about it. That has all been cleaned up by Chase through property preservation. The property's on the market and now under contract. We had 3 offers immediately. So the property is selling for $40,000 to a local investor who you're well aware of, I'm sure, Preferred Homes. Has done a lot of business in Hammond, and we expect to close within 3 weeks.
Preferred Homes is a known contractor in the city. They do good work, according to Mr. Kearney. I'd be happy to give 3 weeks to see if it closes and to ask Mr. Meeker to get the contact. And maybe you already have the contact, but do you need Preferred Homes contact? Or you? No, we got it. Okay. So I'd say set it over for 3 weeks.
Okay.
And that way we can see if it closes. If it does, great. I don't want to stop the closing because of the demo order, and especially because there is a contractor that we know and has done good work in the city that we'd like to make sure that's going to happen. We'll allow it to happen.
Okay, so he will need to return in 3 weeks? Is that the
Yes, to
idea?
report,
Are
or
you
have
okay
the
with
owner
that?
come.
That's fine. One of us just notify Chase so they can remind me to show up.
Same address we notified him at?
Yeah.
Okay.
Yeah, Chase Mortgage. This guy, whatever his name is no longer the owner, and he hasn't returned. We haven't had an issue with him returning or breaking in, but all that is true about removing the walls.
Okay.
Uh,
So
yeah.
is June 20th okay for the date?
June 20th?
June 20th?
Is that a Thursday?
Yeah.
Yep.
Okay.
June 20th at 9 o'clock.
Good for everybody?
Yes, sir.
Motion to set the matter for status for June 20th, 2024.
I second.
All in favor, say aye.
Aye.
Thank you, sir.
Thanks, Steve.
Letter G, 1021 Moss.
1021 Moss, got some additional photos here for you. It also looks like there was a building permit. Actually dated, I don't know why the date says today, but it's just, I think, how they print out sometimes. The computer does that. Okay. So 1021 Moss, the owner is listed as Lou Loomis LLC, which obtained the property of deed. Mr. Jeffrey Pipisar is the attorney for that Lou Loomis. Property shows significant issues, including being boarded up, the siding's collapsing, windows on the second floor boarded up, and there's an unsafe porch. It's a blue house, tab
Yeah.
6 maybe, do you see it there?
Yes, we have the pictures here, the updated pictures.
And there's fire damage, according to Mr. Kearney.
Okay.
So is anybody here for 1021 Moss? All right. Rob, do you want to talk about that building permit? When was that issued, or?
To be honest, I have to confess that I just printed it and I didn't see exactly when that was issued.
Okay. There appears to be a building permit on there, but there's been no work done, so I would request that the order be affirmed, given the condition of the property.
Oh, that's for the demo inspection, sir.
They paid for a demo inspection?
Yes, sir, yep.
Okay, so we'd like to affirm the order. If there's a demo inspection taking place, I'm unsure. kind
I
of
believe we
where
have it scheduled for June 3rd. Yeah.
Okay, so it's set for June 3rd?
Yes, sir.
Don? Okay,
Yep.
so I'd like to affirm the order, and then we'll go ahead and move through the process, but of course, Mr. Kearney will let us know if the demo inspection moves forward.
Gotcha.
Motion to enter the order.
I second.
All in favor, say aye.
Aye.
Okay, letter H, 4625 Sheffield.
4625 Sheffield. Got some additional new photos for you for that property. Kind of in the same bad condition it was in the old photos we have,
fire, yeah.
older photos we have. The owner's listed as a Minerva Kincaid. Inspection report shows a house fire of September 24th, 23. Owner's deceased. There was some family living in the property. Significant and apparent fire damage with multiple structural defects. Structure's been abandoned. The property is fully boarded up. We'd request, given the condition of the property and that no one appears, that the order be affirmed.
Okay,
Motion to affirm.
I second.
all in favor, say aye. Aye. Okay, moving on to letter I, 2104 Sherman.
2104 Sherman, the owner's listed as Stephanie Sotelo out of Dyer. The property shows a garage dilapidated, windows of the house are missing. It's a magnet for graffiti, collapsed fence. Given that no one appears and the condition of the property being an unsafe structure under the act, we request the order be affirmed.
Motion to enter the order.
I second.
All in favor, say aye.
Aye.
Letter J, 918 Willow.
918 Willow, the owner's listed as a Corey Yazaguire of 142nd Street in Hammond. I have some new photos for the board. The rear basement window wall had collapsed. Water's been shut off for non-payment. The gas meter's been removed and shut off. Apparently, the owner may be incarcerated currently. Backyard has abandoned vehicles in it. There's been indications that people have tried to break into the structure, so given the condition of it and that no one appears, we would ask that the order be affirmed.
Motion to enter the order.
I second.
All in favor, say aye.
Aye.
You want all this stuff back? There you go. You're welcome. Okay, letter B, agreement to rehabilitate property at 7601 Golfway Court, submitted for approval.
I believe that the order is signed, and I'd ask for its approval and a status date set at or near the expiration date, which should be on the top of page 1.
Yeah, September 3rd is the date, and it has been
Maybe right
signed.
after Labor Day?
You want to do the
Want
12th,
to do the 12th? Or
Sure.
right-
What's the,
29th?
let's go the 12th, or, yeah,
We can do the 5th of that same week if you'd like.
sure.
Okay.
Okay. Motion to set the matter, motion to approve and set the matter for status for September 5th, 2024.
I second.
All in favor, say aye. Aye. Okay, letter C, right-of-way permits. It looks like there's 3 of them. Received from engineering, submitted for approval.
Good morning.
Good morning, Mark.
So we do have 3 permits, one being a driveway apron and a sidewalk for residential. Second one being Swanell. They're doing some remodeling and doing a driveway. So I would recommend approval of those 2. The third one is from Passion. They are going to do pavement markings, and they're going to have it under flagging. So once it dries, they're going to open it up. So there's multiple streets there.
Okay.
So I would recommend approval.
Okay.
Motion to approve.
I second.
Thank you.
All in favor, say aye.
Aye.
Letter D, request for late rental registration hearing, submitted for approval.
Motion to set it for status for June 20th, 2024.
I second.
All in favor, say aye.
Aye.
Letter E, request for late business license hearing, submitted for approval.
Motion to set the matter for June 13th, 2024.
I second.
All in favor, say aye.
Aye.
Letter F, garage sale permit, submitted for approval. Yeah, we're good.
Motion to approve.
I second.
All in favor, say aye.
Aye.
Letter 10, old business. Letter A, status for 2314 Indianapolis Boulevard.
Anybody here for 2314 Indy? Okay, so I thought Mr. Luter was going to be here, but because of a personal matter, he's not. Mr. Luter's not present today, so I don't have an update for this. 607 State Street, anybody here for that? Okay, 2314 I don't have a status for. All right, so if we could set this over for maybe 30 days,
Okay.
and we'll make sure, Linda, if we can notify the owner.
Status for
June 27th.
June 27th.
That's fine.
Okay.
Motion to set the matter for status for June 27th. 2024.
I second.
All in favor, say aye.
Aye.
Okay, moving on to letter B, status for 607 State Street.
So, 607 State, last time this was in front of us, I was concerned about making sure that the graffiti was taken care of and that there was some fresh paint put on the property. I went by yesterday and took a look, and the graffiti is gone.
Yep.
And I believe I'll let the owner show what the plans are and what's going on, but I believe we're kind of at a good spot right now to allow it to be status for, a little bit further down the road.
Could you give us your name, sir?
Paul Garris.
Okay.
I have plans for doing the outside. The architect took about a month, so.
Do you have an idea of how long that process will take?
We're waiting on the commercial windows right now, so about a month, 5 weeks for that to come in.
Have you been in touch with the building department and/or the planning department just to show them your plans and have them reviewed?
Oh, yeah.
Okay.
Yeah, so we have a permit, bonds, and everything is set for this, so.
So do we need to go something outside of 5 weeks?
I think so. Yeah, we could go
60
probably
days?
like 60 days.
Okay, perfect.
August 1st? Is that okay?
That's a Thursday, right? Yes,
Yeah.
of course. Yes, that's good.
August 1st, okay.
Motion to set the matter for status for August 1st, 2024.
I second.
All in favor, say aye.
Aye.
Thank you, sir. Okay, number 11, number 11, you got me. Letter A, 4105 Wabash, it's a rental registration hearing.
Good morning.
Good morning.
I'm here to represent my mom, Maria Topete.
Could you
My
give us
name
your
is
name,
Melissa
please?
Castro.
Okay,
So the reason why my mom wasn't able to come and pay that fee was because she had to leave to Mexico. She had an urgent phone call that they called her that my grandpa was very sick. So she completely forgot about anything else that she had going on here, and she left to Mexico for like a month.
okay, so we're only here for 24 then, I take it? Okay. Has there been any problems before?
No, I don't show any issues at the property address. It has been registered on time under this owner. They've owned it since 2020. It's a 3-unit property, and the only thing that I did notice was that there is a homestead tax exemption being claimed on the property when the owner does own and live at the property next door at 4107. So we would just request that the owner complete the homestead removal form, which I have here. The highlighted fields need to be filled out by the owner and then returned to us.
Do you understand that?
Yes.
Will your mom be able to fill that out?
She's out here. She's outside.
Oh, she's outside?
Yeah, she
Okay.
just doesn't speak English, so I'm just here to represent her.
Okay, just let her know that we only extend this courtesy usually one time, so just make sure
Okay.
in the future she pays it on time, okay?
Okay.
Okay.
Thank you.
Motion to waive the late fee.
I second.
All in favor, say aye.
Aye.
Thank you. Okay, letter B, 718 Willow Court. Okay. Good morning, sir.
Morning.
Could you give us your name, please?
Oliver Ortiz.
Okay. Could you let us know what happened this year?
Well, the thing is, I just bought the house last year on October. It's first house I'm gonna rent. I didn't know when to pay the rent. To pay the permit for rent.
Okay.
I don't have a renters yet, but I'm not saying I'm not paying the permit. The only thing I come late, it was April 20-something.
Have you ever had renters yet?
No.
Okay.
So what it shows here is that the property was purchased in October 23, and I was able to confirm with water. There was no usage from October to January, so we would accept an affidavit for that time period. However, we would want to make sure that he registered the property because you hit that 90-day period from January 1st through April 15th. It would technically fall under the vacant rent registration ordinance and be required for a $300 fee, but if he would have submitted the rental registration as a new owner, we could have accepted that as well. So we're just here for 2024. It's the first time he's registering it. So I would just note too that there is a homestead still applied to the property. So we would just request that the owner complete this form and then return it to us so that we can have that accurately reflected.
Okay, so you understand, sir, we need an affidavit from you saying that nobody lived there during that entire time. You also need to complete that. And then we are going to waive the late fee for you. Just make sure going forward that you know you have to pay it every year between January 1st and April 15th.
Okay,
Okay?
I will do that.
Okay.
Thank you.
Motion to waive the late fee.
I second.
All in favor, say aye.
Aye.
And sir, if you'd like to wait till the meeting's over, you'll get a copy of this and you can go downstairs and pay it if you'd like.
Okay.
The
I will.
$5. Okay. Thank you. Okay, moving on to letter C, 4325 Baltimore. Thank you.
Good morning.
Good morning, ma'am. Could you give us your name, please?
Laura?
Okay? And could you tell us what happened for 2024?
Yes, usually my husband is the one they always pay, but he's working nights, so he was sleeping in the mornings. So when he told me, it was a couple of days late.
Okay, so you weren't aware it had to be paid, or you just expected him to do it?
No, he usually pay everything.
Right.
But he's not, he wake up like 4 or 5 in the, like, it's too late to come.
Okay.
So when he told me, it was past like 2 days, I think, when I
Okay.
came.
Any problems there before, Nick?
No, it looks like they've been the owner since 2011. They've registered
That's
on
the first
time,
time.
with the only time being late was for 2024.
Okay, so ma'am, we are going to waive the late fee for you, but you have to make sure that somebody pays it between January 1st and April 15th.
Okay.
So one day your husband will have to wake up a little earlier, or you'll have to come down sooner, okay?
Okay.
Okay?
I will.
If you want to wait till after the meeting's over, you'll get a copy and you can pay it today.
Okay.
Okay?
Thank you.
You're welcome.
Motion to waive the late fee.
I second.
All in favor, say aye.
Aye.
Okay, moving on to letter D, 1607 Calumet Avenue.
Morning.
Looks like there's three of them. How you doing, sir?
Good.
Could
Brian
you
Beal.
give us your name?
Yeah, Brian Beal.
Good morning, Mr. Bill. Could you tell us what happened in '24?
I have 3 units. I've had it since '98. I just don't recall seeing the flyer in my water bill to remind me. I've paid it every year. I came here on, I think, the 17th or the 18th of April. Basically just remembered because I've been doing it for all these years.
Okay, those reminders, just so you know, those reminders are done as a courtesy. There's no, it doesn't mean they're going to every year for sure. Just keep that in mind going forward.
Yeah, so it looks like, yeah, he's been the owner since the 90s. The only other problem that we had with the property was in 2015, it looks like the property was sent to collections, and based on our records, I still don't show a registration or anything submitted for that particular year. But other than that, he's registered on time. You know, they accepted 16 and on, but, you know, we'll make sure that year we'll deal with Smiths or Sick then at that point.
Okay, so it's been 9 or 10 years since the
Yeah.
last time?
Yeah.
Okay.
I don't even recall or received notice on that.
Okay.
Okay, I'm sure you probably heard me tell, we only extend that courtesy once, but because there's so much time between the last time and this time, we're probably going to waive it today, but you need to keep in mind, it's got to be paid every year, okay?
Yeah.
$5 is much cheaper than 500, so,
Agreed.
okay?
All right, thank you.
Okay,
Motion to waive the late fee.
I second.
all in favor, say aye.
Aye.
Thank you, sir. Okay, let's see. Letter E, 4319 toll.
I would request the board take no action on this address, as it appears the property was on the agenda for May 16th. The board waived the late fee, and the property is registered for 24.
Okay, no action necessary on letter E. Letter F, 7619 Birch, 20 Waltham, 1246 175th, and 1584 178. Good morning, sir.
My name is Milos Sparalalo. Recently, the company I worked for 18 years closed down, so my mind was preoccupied trying to find another job, and I completely forgot to register the properties. I came here in a couple days after in April, I think it's the 18th, 19th, but unfortunately I was late.
How long have you owned the property, sir?
7619 Birch, probably more than 10 years, 20 Waltham, longer than that. I mean, between 10 and 15 years, maybe some 20. I don't recall exact dates.
Okay. Any problems before?
No, there was no problems with rental registrations prior. However, on 20 Waltham, we do show that there is a homestead tax exemption being claimed here. And so we would definitely need that taken care of since, you know, it is a registered rental property. So if he could just complete this
Sure.
adjustment form for us and then just have it turned back in, that way we can get that corrected.
Okay, thanks.
You know, then that would be appreciated. So we have 1246 175th Street, 20 Waltham. I already gave you the one, right?
Yes,
All right, and then 1584 178th.
they're all one unit for 2024?
Yep.
Okay, good. Yeah.
Motion to waive the late fees.
I second.
All in favor, say aye.
Aye.
Thank you.
Okay, sir, you wait till the meeting's over and you can pay today if you'd like, okay?
Will do.
Okay, thank you.
I think that does it.
Okay.
Thank you.
Thank you.
Okay, the meeting's now open to the public. Does anybody have anything they'd like to say? Come on up, ma'am. Good morning.
All right, so I'm here to talk about 51 Webb Street. All right, I was wondering, when is the garbage gonna be cleaned up?
Yeah, yeah.
I understand you took pictures last week, but, when are we gonna take care of the garbage?
Yeah, so, I mean, as I mentioned last week, you know, the demolition process is moving forward. We're still waiting for title work, actually, and the hearing will probably be in June or July, probably July. But as far as abatement of the garbage, it's Rob's district, I guess we'd have to have a 10-day notice posted. So, Rob, do you have any idea when the 10-day notice will be posted?
I'll post it today.
Okay, so we'll have a 10-day notice posted.
Okay.
And then that'll hopefully mean in 10 days, if it's not removed by the owner, and by the looks of things, it's probably not going to be, based on your experience with them, we'll have to get somebody hired out there and get it removed after that, or Public Works will.
For clarification, is it 10 business days or 10 regular
days.
days? 10 regular days, okay.
So
10
we're
calendar days.
All right, so a timeline about 30 days?
Well, for the garbage to be removed, hopefully it'll be 2 weeks, approximately. But as far as the demolition and the hearing on the demolition, it'll probably be July.
Okay.
And then, of course, after we have the hearing, as you heard maybe with the other demolitions, it still takes time to bid it out, knock it down, so we're still talking probably fall
Okay,
for a demo.
all right.
Thank you, ma'am.
All right, thanks for coming in.
Anybody else like to speak from the public? Okay. At this time, then, we're going to,
Hello, I'm back.
Oh, all right.
I just wanted to revisit my demolition process. I got a little confused on something. So you guys did say if it gets demolition for next week, we'll have 6 to 8 weeks. In those 6 to 8 weeks, is there something that we could do, or is that pretty much like it's already like done deal?
Can you meet with him, Kelly, and explain maybe, or can you explain? Sir, he's going to meet with you outside of this meeting, and he can explain to you, so maybe you better understand.
Oh, okay.
Okay?
All right.
Okay, thank you. Okay. Yeah, and I got one more here, and that's it. Okay. There's that. Okay, now we are going to move on to a grievance hearing. So anybody not associated with the grievance hearing, if they'd like to leave, now would be the time. You can wait out in the hall. She'll give you a copy of the sheets out in the hall if you'd like.
Appreciate it.
You're welcome. What's that? Other stuff. Okay. Okay, a grievance hearing has been requested by the Hammond Firefighters Local 556 Union. This is step 6 of Article 14 of the grievance procedure within the collective bargaining unit. Which one of you are the grievance chair?
That'd be me.
Okay, so I need to ask you, do you agree that all steps in Article 14 have been completed or waived, and we are now on step 6, the final step of the grievance procedure?
Yes.
Okay. Because it is a union's grievance, the union will present first, then the city will have an opportunity to respond. Lastly, the union will have a chance to reply to the city's response. And, Mr. Chair, you can go ahead and begin.
Well, I would like to start off with first to make note, give a little history that our member Danny Mishak was promoted to assistant chief position rank on April 22nd, 2021.
Could you do me a favor? Just, could you give us your name for the record?
Jeff Hartleroad.
I called you Mr. Chair, but I'm sure you don't want to be
No
called
problem.
Mr. Chair. So, okay. Go ahead, sorry about
So
that.
he was promoted to the rank of assistant chief back in 2021, served as chief inspector for all the time up till recently. Before this board on April 3rd, it was recommended by Fire Chief Jeff Smith that Mr. Mishak be reassigned to private, the rank of private. And at that time, it's our contention that he was improperly reassigned, demoted without cause. He wasn't granted his contractual obligation of any kind of investigation, any kind of information, any kind of notification. It was brought to the board preemptively before any of that, was not notified of any kind of disciplinary action given to him. We've requested his records. Due to his Hammond Fire Department record, there's no record of him of any kind of disciplinary action. The only thing in his record is his hiring information, medical information, and letters of accommodation. So we presented a grievance that his due process and rights were violated through the collective bargaining agreement and state law. And we offered a few resolutions for the fire chief to agree with us to either put him back immediately to the position of assistant chief, go ahead and reassign him to private, but he needs to be paid at the assistant rank position because he shouldn't be demoted and or reassigned with any loss of pay without cause. So those resolutions were offered. They were declined. The board, your board here, reassigned him without any of the notification prior. So we're asking that this be reversed. Him either be put back as assistant chief inspector, maybe even the vacancy that is now open, assistant chief drill master. These are options available to them, but he should be reinstated to the rank of assistant chief. And make sure that moving forward, that the collective bargaining agreement is followed for all our members. That's agreed to by the city, the union, and approved by the Board of Works here. So hopefully everybody here would adhere to the collective bargaining agreement.
Okay. Do you have anybody else that's going to speak today?
President Hall might speak at the end.
Yeah, okay. I mean after the city spoke?
The
or
city,
I
yes.
got you what you're saying. Anybody else right now? Nobody else right now? Okay, so then we're going to go back to the city then, okay? Okay, Mr. Smith, I would like you to begin if you're ready.
Kevin Smith, Corporation Counsel for the city, on behalf of the city and administration, Fire Chief, Chief Smith, and Deputy Chief Grizzoli, of course, now Fire Chief Grizzoli, or maybe it's like we're within 24 hours of that, I think. So just a couple things. First and foremost, I don't believe Mr. Hartleroad presented the board with the grievance. However, we do have a copy of it. And just to state generally, I believe, number one, there's a due process argument. However, I don't believe Mr. Hartleroad presented the board at this time, nor at any other time in the process, any indication of what that due process harm was. They've indicated that there was failure to provide notification, failure to provide documents. However, I would note that the statutory process that Mr. Miziak asked for has been complied with. For example, and I'll make this an exhibit. The board already has the letter from Chief Smith that Mr. Hartleroad referred to, which reassigned and demoted Mr. Miziak to the rank of private. That was approved by the board on April 4th. I'll mark that as Exhibit 1. And I'll have some testimony from Chief Grizzolia in a second. However, I do want to present the board with some documents first. So this is Exhibit 1. You see it? Yes. So the next thing I'd like to present to the board would be Exhibit 2, which specifically was a e-correspondence email sent on April 4th at 12:04 p.m. from Dan Miziak at Hammond Fire, miziakd@hammondfire.com to the fire chief, deputy fire chief, myself, Jeff Long, and CC'd Michael Hull, which requested, within the statutory time period under Indiana Code 36-8-3-4, a request for a hearing before the board. I responded immediately, I believe on that same date, or no, I'm sorry, I responded on Monday, April 8th, indicating to Mr. Misiak that I confirmed receipt of his request for hearing. I advised him that we'd be setting it on or before May 4th pursuant to the code. I also let him know written notice of the hearing will be given to you at least 14 days in advance to comply with the Indiana code. Asked him if he'd like to coordinate an agreed date to please contact Linda. And I also indicated at that time we would intend to utilize the following testimony and evidence. I listed Chief Smith, Deputy Chief Grisolia, Wendy Adams, Lori Autry, Assistant Chief David Weiss, Phil Sharinga, David Lee, Sharon Daniels, various Hammond police officers and witnesses that may be necessary to prove the charges against you of conduct unbecoming. Documents may include Facebook posts, police reports, criminal records, medical records, personnel files, photographs, and other documents that may be required for the hearing and to prove the charge against you of conduct unbecoming. So I'm going to make that Exhibit 2, which is my email and Mr. Misiak's email to various persons. That's Exhibit 2. And then finally, I'd like to make Exhibit 3, the statutory notice of hearing that we sent out and was hand-delivered, I believe, to Mr. Misiak by the fire chief at his home or wherever he was at the time, might have been at the station. And this is the notice of hearing, the statutory notice, setting it originally for April 25th. Mr. Misiak is currently represented by an attorney, and we have agreed. That date was requested to be continued by his attorney, and we coordinated a date with his attorney for June 7th of 2024, I believe. Linda, right? June 7th of so it's next week, I believe, at 10 a.m., I believe. So that is Exhibit 3. I'll make sure Mr. Hartler has a copy of that. Well, I requested Exhibits 1, 2, and 3 be made part of the record. Oh, I do have a copy of I thought I had an extra copy of the grievance. Let's see.
We have some copies.
Okay.
That was one of the things we weren't I don't know what you guys have copies of or not, because you guys work with the city, obviously. So I thought this was presented to you already.
Okay.
So I guess kind of in total, what I would say is, number one, the procedures were followed in substantial conformity with what is required. Mr. Misiak was informed of the charge against him of conduct unbecoming. We believe that charge will be able to be proven before this board under the statutory notice when it's heard next June 7th. Mr. Hartler has not presented any harm as a result of any what I would call minor inconsistencies with the procedure under either Article 13 or Article 14 of the collective bargaining agreement. I would like to call Chief Grisolia up here for a second just to give some very quick testimony.
Chief, could you raise your right hand, please? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Chief, could you please state your name
Bernard Grizzlia.
and your rank at the Hammond Fire Department this time?
Currently Deputy Fire Chief. I'll be Fire Chief June 1st.
Did you have occasion to meet with Danny Misiak on April 3rd, 2024?
Yes, I did.
And was that in your office?
Yes.
Who else was present?
Sharon Daniels was witnessed.
All right, and how long did that meeting last in total?
It was quick, within minutes.
All right, and did you advise him at that time that he was being reassigned and demoted to private?
Yes, we had a discussion. I did advise Danny Misiak that he was...
Jake? Sorry, Jake? Jake? We can hear you very loudly. Sorry.
Okay.
Go ahead.
I want to make sure everybody heard. the
Yes,
answer.
please,
Yep.
yes.
You want to repeat the question?
Sure, you can read.
Okay.
Sure. We had a discussion in my office.
Right, it was a couple minutes, all right. it was quick. How did the meeting end? Did you end the meeting or did Mr. Misiak end the meeting?
Mr. Misiak did end the meeting. He did get angry, upset. He stormed out of the office.
Okay, at that time when he stormed out, before he stormed out, did you have the opportunity to let him know that union representation was available to him?
No, sir, I didn't have the chance, no.
Okay, and did you have the opportunity to show him the documents like his personnel file and anything else that would have been required at that meeting because he stormed out?
No, we did not have enough time. He took off.
All right, that's all the questions I have. Thank you.
Okay, thank you.
Is it open for questions? Are we allowed to ask?
Can they do it now or call him back up when it's
Do
their
we call
turn?
him back up? I'm not
Okay.
familiar with the.
Sorry, go ahead.
The process.
Yes.
So in that meeting, you called him, what was the date of that meeting?
April 3rd.
April 3rd, the day before the Board of Works meeting?
Correct, yes.
Okay. Did you notify him prior that he was coming in, that he was under investigation, that he was going to be disciplined? Did you tell him that he was going to have the ability to have union representation or legal representation prior to coming into that meeting? And did you give him notice of that meeting 72 hours in advance?
I asked Danny to come in that morning, and he did show up, and we had a discussion. We never had a chance to talk about anything. He stormed out.
Yes.
That was the end of the meeting.
So, but prior to the meeting, it was that day that you recommended he come in. And let me ask you this also, it's two-part. Was Danny on a medical leave during that time? Off work with an injury, illness?
He was off, he was on a no duty.
On a medical leave, right?
I'm not here to discuss that. He was on no duty.
It's either medical leave or injury, illness. I mean, I don't know what
Is
no
that a
duty
HIPAA
is.
thing? Is that,
I think he asked the question, you answered the best.
Yes, I'm just trying to give a little
Okay.
respect here.
I think we got the idea. We got the
Okay,
idea.
no
So,
problem.
yeah.
No duty status.
We're good, we're good.
I got you.
Okay. Go ahead.
Do you have anything? I think we're good for now.
Good for now? Okay.
I don't have
Thank-
any follow-up questions.
Okay, thank you, chief.
Okay, thank you.
Okay.
So, I guess, again, the city's position is that at this point in the grievance procedure, which is step 6, which I appreciate Jeff agreeing that we've kind of got to this point, waived everything, either waived or already has happened through steps 1 through 5, so we're here. I believe the city's position is that we've complied with the grievance procedure number 1, 2, that we've complied with the statutory requirements that in the grievance form, Mr. Misiak stated that, you know, he states all this complaint about the statute's not being followed. The statute has been followed. That's why we're here next June 7th. And he's going to get his day before the board. He's going to have his attorney here, I assume. We're going to have testimony from multiple witnesses. We've got documents from, you know, the police department, the Facebook, various casinos. We've got all kinds of documentation that we're going to put before the board that I think supports the charge of conduct unbecoming. So that is going to be heard, and I believe that does satisfy his due process. If there were any minor things that weren't followed within the grievance procedure, there's been no showing of harm because he did notify us that he wanted a statutory hearing. He's going to get it. So I believe for those reasons, the city and the administrations and the fire department stands with their original discipline, which is to reassign and demote Mr. Misiak from Assistant Chief Drill Master to Private dash P, I believe. Is that right, Bernie? What's the rank? Private? Private paramedic, yes. Private paramedic, so.
Okay. Is the city done?
Yes.
Okay. Mr. Alterode, would you like to respond to the city?
Yes, we would. This is kind of somewhat new to us, so when I'm presenting this case, I didn't realize what you have and didn't have along with the grievance. So I present you with the grievance. I don't have stickers to put on these things, but you have the grievance. But if you read if you guys had a chance to read through the grievance, it does list all the articles and subsections in the collective bargaining agreement that he feels he was harmed with. I don't know if I need to sticker this, but this is a printout. That lists them. This is from the collective bargaining agreement.
Okay.
And that is a printout of all the different articles that are listed and the way it's read in the collective bargaining agreement. So you have an opportunity to review that and back up his claim on how he was violated his due process. We feel that I know that a hearing is set for Mr. Misiak, and he did request a hearing. That was after the Board of Works already made their move or made their recommendation to reassign him to private. Through the collective and bargaining agreement and through the state code, he's supposed to be offered his notification of any kind of disciplinary action. He's supposed to be able to have evidence presented, have the hearing prior to the Board of Works making a decision on whether there's going to be a reassignment or demotion. He didn't have that opportunity. That's why the grievance was filed. That's why we went through these steps to get to this actual hearing over the fact that he was demoted without cause. To this day, we still do not have any kind of disciplinary action in his file, notified to him whatsoever. It may have been a meeting that morning, called in while he was on a medical leave, with PTSD, was told that he was going to be demoted due to conduct unbecoming. But there's still no notification. There's nothing in his file. There's no paperwork anywhere. Other than the fact that you've already made the move or already voted to reassign him. So there's no mention of conduct unbecoming. There's no disciplinary action. That's where we feel like his process was violated.
Okay.
Money has been taken away from him. I will notice here that this is state code of any kind of notification of disciplinary measures. It's pretty bold, but it says here that if he's to be dismissed, transferred, reassigned.
Sorry, Jeff, what code are we looking at?
Sorry, go ahead.
Go ahead.
It's section 36-8-2.1-9. It's titled Notification of Disciplinary Measures. And then
So-
the other IC codes are 36-8-3-4 and 36-8-10-11 are the ones there.
I believe 36.834 is a disciplinary statute that lays out the process for sending any kind of disciplinary action. This one covers the fact that there's a process that needs to be followed also if you're going to be doing this. Any kind of disciplinary action like this, you're going to reassign somebody with a monetary loss, which has already been done. Along in the same 36.82 is the fact that notification needs to be done 72 hours need to be given.
I'm sorry, Joe. I just want to make sure I have the right site. 36-8- regarding the notice. 36-8-
Notification is 36-8-2.1-9.
And along this is 36.8-2.2-6, which is you need to give 72 hours to obtain representation. So these are state statutes that are listed that give him his due process, but it's also listed in our collective bargaining agreement that you follow, that if you're going to discipline somebody, that there's a whole process that needs to be done. And that whole thing was missed, which is in part of the grievance, which is labeled I think it's under 13.3, Article 13, so in the contract. So that lists, that would show you the process if you're going to be doing a disciplinary action. So our contention is that everything was missed. His whole process was violated. The hearing, you guys already had a hearing. You've already demoted him to private. So he had no choice but to appeal on his own that particular ruling. After that was done, the action where he has already been harmed prompted the grievance to be filed and the union to have to step in on his behalf.
Yeah, I just want to say one thing, and that is that, regarding there's two processes here, right? There's the action that was taken, and I think they're getting conflated. The action that was taken was the action by the chief that was then reported to the board and entered by the board, and that was the reassignment/demotion of Mr. Misiak. Then the hearing procedure of that action is the hearing that we're going to have next week under the statute. And so I disagree with the position that union's taking regarding that there should have been some hearing on the action. That's what's happening next week. That's why that 36-8-3-4 is there, to set out, this is how you appeal, this is how you get a hearing on the action. So in my mind, and in our opinion, that is happening. The action that was taken, if he disagrees with that, that's the grievance. I guess he can also grieve, and that's why the union's grieving to make sure that the steps are being followed. But that has nothing to do with the statutory hearing that he's going to get as a result of the action, because that for sure is being heard next week, and we're going to present on that. Mr. Hartleroad's correct that the grievance does set out several articles within the CBA. They set out Article 5.1, which I would just say has to do with employee status. It's totally in the chief's discretion as to whether they give the union notice, so I don't think that was violated. Article 6, discrimination. They list alcoholism as a disability, which it's not. I mean, it just simply isn't a disability. There's a, if you're in active recovery, it can be a disability, but there's no indication of that. And so also, again, there's nothing in the law that says you can't demote someone and because of actions taken, notwithstanding a disability. So that's where the city's position is on that. Article 12, they mentioned about being fair and equitable administration should be enforced. We believe that, I mean, our position is that it was fairly and equitably given. And then also discipline and discharge, section 13.1, that has to do with, they mention in there that they acknowledge that the issue is conduct unbecoming, and they talk about documents and other things that weren't given. You heard the testimony of Chief Grisolia that mentions why that wasn't done. And then it gets into the statute, which I indicated through the exhibits and through my argument to the board that has been complied with. So that's where we stand on that. I just wanted to make sure that point was being made, that we're in kind of, there's two different things going on here, and the one that's going to be heard is next week for the statutory hearing.
So, if I may, I don't know if there's something getting lost in translation here, but I think they're saying that meeting, that initial meeting that happened with Bernie shouldn't have happened without 72-hour notice to have representation there, and that didn't happen. So then the action takes place without that 72-hour notice taking place. I don't know if you agree with that, Mr. Smith.
I'm just checking the statute.
Yeah, that,
Well, we can give you the verbiage from.
I mean, is
here.
that what you guys are, is
Yeah,
that your
I mean,
point?
So we
Okay.
go off of our collective bargaining agreement and then also the rules and regulations, and they both have writing that state those are the requirements.
Kevin. I mean, that's a readable version, I guess you could say, for 72 hours.
That's 2.2 and this is 2.1, yeah. So 2.2, I'm not sure applies to the city fire department. Thanks, Jeff. And 2.1, okay, so what 36A 2.19 says is a public safety officer may not, except as provided in IC 36834, which is the here, 36834 is what we're doing next week, right? Be dismissed, transferred, reassigned, subjected to a personal action that may result in the loss of pay or benefits, or be subject to a disciplinary measure resulting in monetary loss, unless the public safety officer is notified of the action, which he was notified of the action, that was in Bernie's office, and the reason for the action in advance of the effective date of the action. The reason is in the letter, which is the April 4th, is notified conduct unbecoming and in advance of the effective date of the action. The effective date was right after that. So he was notified. And I think we complied with 36A 2.19. I know that Mr. Hartleroad has a different take on it, but our position is that we complied with it. And I'm looking right now to see if 2.2 applies, but I can get back to the board on that.
Okay.
Yeah, to us, you know, the state law 36834 for discipline demotion that it's referring to, that's one of the reasons that they can do this, lays it out that you have to be notified of this, you have to be given the opportunity, that basically be told what your charges are, and then you can request a hearing here before, so you have an opportunity to plead your case before the Board of Works before action is taken. This wasn't given the proper notice telling him that he was going to be reassigned, demoted due to conduct unbecoming. Again, I mentioned that no conduct unbecoming, no disciplinary action has ever been given or issued to Mr. Mishak, all the way up until this date. So he has no information, basically, to tell him that he has been disciplined, other than the action taken by the board requested by the chief to be reassigned. And reassigned and demoted due to some disciplinary action. The disciplinary action usually comes first, and then there's an action that you're notified of this, so he has an opportunity to have his representation and can follow the. So it is our contention. I understand that you guys took action and he asked for a hearing, that he felt he needed to do with his attorney. That's why he filed the grievance, because the action was already done, it was already taken against him, and he's been, and we have to follow this process to get to your guys' decision here, so he could appeal this decision through court. If you read through the whole statute and everything that tells you the layout and the process that is involved, he has to have a hearing before the Board of Works and a decision made by you that he could appeal in Superior Court. So that's where we're at in our view today. His hearing, that's appealing the action already taken, that's a separate issue than what he's provided to through the union. And it is our contention that he was not notified with enough time. I mean, calling somebody the day before in the morning and have him come in while on medical leave to tell him that he's being demoted, not offered any kind of information, it's not proper. He needs to have his notification. He needs to be able to have his representation with him, people that know the process that should be followed. So we feel that it was done properly.
Okay. Good morning, Mr. Hall.
Good morning. How are you?
Good, good.
Good. It's unfortunate, obviously, that all of us are here and that everybody's going through this. We've all been on the same sides of many cases. But I kind of just want to give a summary and break it down in the simplest of terms. We had a member who was diagnosed with PTSD. While he was off with PTSD clinically, being treated, he was demoted. I can't see any police officer, firefighter, any city employee that would be okay with that. I can't see any human that would be okay with that. It's downright dirty. You could wait till the guy gets back, have the talks with him, have the hearings, whatever. You don't discipline somebody when they're off with PTSD. That's going to be a nightmare for this city in its own, and it's a shame. This member was never made aware that there was an investigation against him. He wasn't afforded that right. The union was never notified of an investigation against him. The member's records had to be requested twice before we received them. Obviously, once we received them, we found there was nothing in there. There were 0 disciplinary actions and only accolades, which is another odd thing, to be demoting somebody who has 0 disciplinary actions. The actions that were taken, the disciplinary actions, those are not even an option in our collective bargaining agreement. Our collective bargaining agreement has steps that can be followed. It's oral reprimand, written reprimand, suspension, termination. Those are our options. Those were what was agreed upon before from the firefighters with the city and signed off by the Board of Works. And so here we are going outside of that again. Firefighters are watching this. I'm sure the police are watching this, and they're seeing, well, wait a minute, if they could just go against anything that they agreed to, what good is it? What good is it sitting down with the city and coming up with these agreements? I think that in the past few years especially, we've prided ourselves on doing things in the public, protecting the residents, protecting our members, protecting the city, but we also call everybody out. We call out our own members. You wouldn't believe it. I say it often that I'm a bigger a-hole to our members than the chiefs or the city will ever be. And I take pride in that because I hold them to a high standard. But if they're not willing to act in the correct ways, if I come down and say, hey, Dan, what's going on here, man? Maybe you got a few problems. We got to address this before it gets out of hand. That's what it would take. But if there's 0 written, oral, suspension, anything up until that point, how do we just go from the 0 to 100? I mean, it's just not consistent. I think that this action is going to jeopardize a lot. It's going to jeopardize to protect our member, obviously, but it also jeopardizes this city, and it's going to jeopardize the public. And how it's going to jeopardize it is with a lawsuit. We know that that's the direction this is headed, and I'm just trying to be blunt and honest. I know Kevin and I have talked, obviously Danny and I have talked. This is going to cost the city a lot of money in the end, and I think everybody can agree to that once they see everything before them, and I would hate for it to get to that point. There is an open vacancy right now for assistant chief. Danny should be given the opportunity to be put back in that place. And you know what? If Danny screws up, now you go through the correct procedure and you do it the right way. But let's do it the right way once and for all. Give him the opportunity, or, he'll sink or swim on his own. But I think he should be given that opportunity based on what's in writing. And that's really it. Appreciate it.
Thank you, Mr. Hall. Are you guys done? You done, Jeff?
Yeah, I think Mike summed it up pretty well. I think we need to follow things properly. That's our contention again. Not everything was followed to the letter of the contract, which everybody has agreed upon. So we are asking for reinstatement until they could figure out another way or another process, I guess. And that's it.
Okay, thank you. City, have anything?
I just want to make real clear something Mike said. You know, Mr. Misiak was not demoted because of his PTSD. He was demoted for conduct unbecoming, and that's going to be what's going to be heard next week. I mean, there's a litany of items that are, you know, not going to be, frankly, they're embarrassing for both, you know, the city, the fire department, and Mr. Misiak, but we have to present it because that's what we have to do next week, because he's asked for a hearing on the charges. And so we're going to have that hearing, and of course, he has the right after that hearing to take whatever next steps he needs to take. I think we have a fundamental disagreement over how discipline has to be doled out. I mean, I think if the charges or if the conduct is such that it reaches termination, that we've had situations like this. Heck, we've had one in the fire department not that long ago where there was termination. There wasn't any, like, you know, stepped up discipline. And so, and this, by the way, this isn't a termination. This is a demotion and a reassignment, which is at the chief's discretion. And so, you know, we'll present next week. I think any harm that either Mr. Hartler-Road or Mr. Hull brought up regarding the process has not resulted in any due process harm, because, again, Mr. Misiak's going to get his day next week here before this board, and then if he chooses or if the city chooses, a day beyond that. So, again, all I would say that at this point is that we believe that the process was followed and that next week will be the step in the statutory process.
Okay, I just want to, this concludes the grievance hearing. The board will now take this matter under advisement and issue a decision within a reasonable amount of time. I just want to make sure everybody understands that. As soon as possible, we'll make a decision, just so you guys know. Same for the city. So we're gonna conclude today's grievance hearing, and thank you guys for coming. Thank you. Okay. 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 I'll take to adjourn the meeting.
Motion to adjourn.
I second.
All in favor, say aye.
Aye.
Thanks, everyone. Yeah, I got it.